We are diving into, well, a monumental and frankly a very complex piece of legislation today.
Hmm.
A new comprehensive U.S. immigration reform law has just passed, and it is. It's just reshaping the legal landscape for millions of non-citizens across the country.
Right. And this isn't just a tweak, it's, a dramatic, possibly a generational shift in modern American immigration history.
Generational shift.
Yeah, I think so. If we connect this to the bigger picture, this reform fundamentally alters how the United States treats anyone who is not a citizen.
Anyone.
Yes, regardless of how long they've been here, what their status was before. It's a whole new ballgame.
So our mission today is just absolute clarity. I think when laws shift this dramatically, especially in an area as sensitive and, personal as immigration status,
Oh, absolutely.
simply reading the headlines is not enough. You need to understand the mechanics, the specific details, and maybe the implications that are sort of hidden in the text. We've looked at a massive stack of source materials, articles, legislative analyses, legal memos, all detailing this new law. And what stands out immediately is the really unexpected political context.
That political context is remarkable. I mean, this is historic because the law passed with strong bipartisan support.
Bipartisan.
Democrats and Republicans coming together in a rare display of cooperation that, frankly, stunned a lot of observers in the Beltway.
And what's so fascinating here is when this happened.
Hmm.
The sources all highlight that this comprehensive action was approved during the second term of the Donald Trump administration.
Which nobody saw coming.
Nobody. The conventional wisdom for decades, I mean literally decades, has been that gridlock and political polarization would prevent any movement on immigration.
Let alone something this comprehensive.
Exactly. Not legislation that carries both severe enforcement measures and at the same time significant opportunities for legalization. Yet, here we are.
And that cooperation, it signals something really important. It shows the federal government, regardless of party, has sort of achieved a new consensus on a baseline for who is allowed to stay and, maybe more importantly, under what conditions.
Nobody predicted the specific outcome, and certainly nobody expected the details inside the legislation to be this severe in certain areas,
Right.
while at the same time opening up these long-awaited pathways in others.
It truly represents a new political compromise. It's tough, but it's also expansive in a way that's really kind of unprecedented.
And those specific details are the core of our exploration today. This law is really a duality.
It is.
It offers real hope and, expanded opportunities for millions who have been waiting to legalize their status, but at the same time, it implements these devastatingly strict consequences for others.
The stakes are just fundamentally redefined now.
We're talking about situations where something that used to be viewed as, I don't know, a costly mistake, like a misdemeanor, driving under the influence,
DUI, yeah.
it could now become a life-altering event. Something capable of destroying everything an immigrant, including a long-term green card holder, has built in America.
That assessment is absolutely correct.
Yeah.
This legislation is a major turning point. It doesn't close the door entirely, but it raises the bar so high and dramatically narrows the margin for error in ways that will directly affect millions of people, especially those who have been residents for a very long time and maybe felt comfortable or, secure in their status.
So we have two major areas of focus for this deep dive. First, we really need to understand the tightening of these enforcement rules.
Right.
And that starts with the technical but profound reclassification of permanent residence and the resulting erosion of green card security. We're going to analyze how this new classification really weaponizes minor infractions.
And then second, we'll look at the other side of the coin, the creation of new legalization pathways, the positive side of this compromise, and then we have to dissect the demanding new requirements for eligibility.
Specifically, that high and newly stringent bar of good moral character.
Yes, the GMC requirement.
The crucial takeaway we need to impart today is that the legal and behavioral standards for non-citizens have just been dramatically raised. Even common, seemingly minor mistakes could now trigger a catastrophe.
Right.
It makes the pursuit of full U.S. citizenship not just a desirable option anymore, but an existential necessity for huge segments of the non-citizen population.
We're moving from a system that offered, nuanced discretionary relief to a system that's predicated on near zero tolerance for very specific behaviors.
Let's jump right into that first major shift, which, as we mentioned, sounds technical, but it carries these colossal consequences. This is the official reclassification of all immigrants who are not citizens.
This is a classic example of how a seemingly innocuous change in language, buried in a massive legislative text, can just dismantle decades of legal precedent.
Okay, so let's unpack this with some depth. Under the new reform, anyone who is not a United States citizen will now be officially labeled a non-citizen. Simple enough on the surface. This terminology is now consistently applied across all the relevant statutes within the Immigration and Nationality Act. But what is the practical, the tangible impact of this, particularly for long-term permanent residents, green card holders?
The practical impact lies in the history of how they were treated, both judicially and administratively. Before this reform, the law often created a distinct, sort of protected legal space for permanent residents.
Okay.
While legally they were still technically aliens, their status gave them certain privileges, namely access to specific waivers and defenses against deportation that were just unavailable to people on temporary visas.
Can you give us an example of how that protection worked, in the real world historically?
Certainly. Let's consider the concept of cancellation of removal under the Immigration and Nationality Act. For a permanent resident, a green card holder, the bar for getting relief from deportation was historically lower than for someone without that status.
Lower how?
Well, they might have been eligible for what was essentially a judicial pardon, provided they met certain long-term residence requirements and could show strong community ties.
Even after committing a crime?
Even after committing a serious offense, as long as it wasn't an aggravated felony, their status as a permanent member of society just gave them more leverage in a courtroom. The judge could weigh the good against the bad.
So they were essentially seen as vested stakeholders who deserved a higher level of due process and maybe a second chance, unless they did something truly heinous.
Precisely. They were seen as near citizens. They enjoyed greater security, stability, and a distinct set of legal rights that were explicitly different from, say, someone holding an F-1 student visa or an H-1B temporary work visa.
But the new reality following this reclassification is that green card holders are now basically placed on the same legal ground as everyone else.
Exactly. Temporary visa holders, international students, work permit recipients, nearly everyone who is not yet naturalized. They are all simply non-citizens when it comes to these enforcement mechanisms.
And that homogenization is the critical part.
It is. It signals that the government is no longer obligated by statute to maintain those separate, more lenient standards for green card holders when it comes to inadmissibility and deportability.
So if a rule applies to a temporary non-citizen,
It can now be applied with equal or sometimes even greater severity to a permanent non-citizen.
so the government no longer has to maintain these two separate sets of criteria, one for temporary visitors and one for permanent residents, when it decides who gets to stay. How does this reclassification specifically, streamline enforcement for them?
It simplifies the whole process by removing layers of discretion, both administrative and judicial. The specific statutory language in the new reform links several mandatory grounds of deportability, which were previously reserved for temporary status holders, directly to this new universal non-citizen classification.
To the shortcut.
It's a legal shortcut, yeah. It allows the government to invoke those stricter rules without having to navigate all the previous exceptions that were built into the law to protect permanent residents.
This means the government can use the same aggressive legal tools to remove a long-term resident who has built a life here for 30 years, as they would use to remove a tourist who overstayed their visa by 3 weeks. The protection they assumed they had is it's eroding right beneath them.
That's exactly right. For decades, many permanent residents lived under what the sources are calling the illusion of protection.
The illusion of protection.
They viewed their green card as a near guarantee of permanence. And while immigration law always allowed for revocation under certain serious conditions, the new law has drastically expanded the government's authority to revoke that status, and more importantly, it's removed the judicial safety valves.
So the point where that protection ends
Is now sharper, clearer, and far more dangerous than it has ever been before.
it effectively reduces the legal distance between a student visa holder and someone who has lived and paid taxes and contributed to the country for 2 or 3 decades.
It does.
That shift in legal classification, even if it seems like a minor thing on paper, is the foundation for all these stricter enforcement rules. It just removes this long-standing layer of implicit security that came with that status.
It does, and it signals a profound change in legal philosophy.
Yeah.
Government is essentially saying, until you are a citizen, your status is conditional.
And those conditions are now uniform.
Uniform and strictly enforced across the entire non-citizen spectrum. The law no longer primarily values the length of your residence or the depth of your community ties when you've committed one of these violations. It prioritizes universal compliance, full stop.
Before we move on, I want to probe this illusion of protection idea a little more. Was there a specific legal tool, like a common waiver that green card holders relied on that is now explicitly gone because of this reclassification?
Absolutely. One of the most common forms of relief that is now severely restricted is the judicial waiver that can be pursued in certain circumstances. Previously, if a long-term green card holder had a specific single crime, often not an aggravated felony, they could seek relief from the immigration court. The court could weigh the equities.
The good versus the bad, like you said.
Exactly. The harm of the crime versus the years of good behavior, the family ties, the contributions, the reclassification, and the statutory changes that follow effectively eliminate the immigration judge's ability to grant that waiver for a much wider range of offenses.
Including the one we're about to talk about.
Including, critically, the one we are about to discuss, the DUI.
So the law doesn't just define the infraction as serious, it removes the judicial mechanism that could have historically softened the consequences based on an individual's life story.
That is the true loss of security for the permanent resident population.
The loss of the safety net.
It is. And this reclassification lays the groundwork for universal enforcement. And nothing demonstrates that new universal threat, quite like the sudden profound change regarding driving under the influence offenses.
And this brings us to what is easily the most controversial and alarming part of the entire reform. The detail that has caused the most concern within immigrant communities and among legal practitioners, this drastic change regarding driving under the influence, or DUI, offenses.
This is where the severity of the new law becomes immediate, explicit, and potentially devastating for millions. It takes what was historically a common state-level offense and elevates it to a federal immigration-mandated deportable offense.
Right. Historically, a first-time DUI was handled almost exclusively through state courts.
Yeah, state or local, right?
It might result in a fine, community service, probation, some required classes. And while lawyers would warn about potential immigration consequences, those consequences were always complex.
Very complex. It depended on whether the offense was classified as a crime involving moral turpitude, or a CIMT if there were aggravating factors like an injury or multiple offenses, or if the sentence was over a certain length.
But the average person generally just moved on with their lives after satisfying the state court.
That entire landscape has been bulldozed. Under this new federal law, a single DUI involving alcohol or drugs is now grounds for inadmissibility and automatic deportation for non-citizens.
And crucially, the federal law now overrides the state classifications entirely when it comes to immigration consequences.
That is the critical distinction. A single offense, which might be a simple traffic misdemeanor in, say, California or Texas, can now trigger the ultimate federal immigration penalty.
Let's make sure we are crystal clear about what inadmissible means in this new context, because the term's application has really changed.
It has. Inadmissibility is the government's legal determination that you do not qualify to enter or remain in the United States. Now, under the previous regime, green card holders were generally protected from most grounds of inadmissibility unless they traveled abroad and tried to return.
Right.
The new law leverages that non-citizen reclassification we just talked about to apply a ground of inadmissibility, specifically the new DUI ground to long-term residence internally.
So, even if the person has lived here, worked here, owned a home here for decades, if they're labeled inadmissible because of a DUI, the legal basis for their permanent residency just dissolves.
And if they travel, say a green card holder visits family overseas and tries to return, if the government labels them inadmissible based on this new DUI rule, they can be stopped at the border and refused re-entry, despite their valid green card.
And that's scary enough.
But the sources emphasize the most alarming detail. They can be deemed inadmissible without ever leaving the country.
Okay, how does that work?
Simply because the law now states that due to that DUI, they no longer qualify to remain in the country. They can be placed directly into expedited deportation proceedings from inside the U.S.
That changes the nature of the threat completely. It means the jeopardy is immediate and internal, not just something triggered by travel.
Exactly.
And the specificity here matters. The law treats every DUI the same way, regardless of state classification or whether it was a first offense.
Exactly. The source material is unequivocal. It doesn't matter if you've lived here for 25 years. It doesn't matter if you've paid millions in taxes or raised 5 American citizen children.
It doesn't matter.
If that person commits this single offense behind the wheel, they could lose their green card and their ability to ever return to the country they called home. Furthermore, the mandatory nature of this rule means the immigration judge has virtually no discretion to weigh those mitigating factors.
The things we just talked about.
The ties to the community, the family situation, all the things that historically allowed for relief, that's gone.
That paints such a stark picture of zero tolerance.
Yeah.
Did the sources indicate any mechanism for appeal or mitigation for long-term residents? I mean, surely Congress built in some safety valve for someone with decades of exemplary residence.
The reform explicitly offers no comprehensive room for second chances under this new rule. It is designed to be a hard, bright line.
No exceptions.
Well, there are highly specialized, extremely limited waivers for certain family members who might suffer extreme hardship. But those are complex, highly restrictive, and not automatically applicable to the person facing deportation themselves.
So for the non-citizen individual?
There is no opportunity to appeal based on decades of good behavior or community ties that courts might have considered in the past. The federal treatment of a DUI for non-citizens is now fixed. It is a deportable and inadmissible offense.
This level of severity forces us to ask, how does this new federal rule square with the historical concept of a crime involving moral turpitude, or CIMT? Because, traditionally, immigration consequences really hinged on whether an offense was a CIMT.
That is a critical technical distinction. Historically, a simple, non-aggravated DUI was generally not considered the CIMT.
Why not?
CIMTs usually involve crimes of, baseness, vileness, or depravity, like fraud, theft, or assault with intent to harm. Because a DUI is a crime of negligence or recklessness, it usually fell outside the CIMT definition, which protected many immigrants from automatic removal.
But the new law just bypasses the CIMT requirement entirely.
Precisely. The new reform creates a standalone statutory ground of inadmissibility and deportability, specifically for DUI offenses committed by non-citizens. It doesn't need to be defined as a CIMT. The new law simply makes it a federal immigration offense with mandatory consequences.
Regardless of the state classification.
Right. This is how Congress achieves such a dramatic enforcement shift, by legislating a new specific immigration penalty rather than trying to fit the DUI into the old CIMT box.
And here's where it gets, terrifyingly nuanced for the general public. The law doesn't only apply to criminal convictions, but also to admissions of guilt. This expands the reach of this law exponentially, way beyond the courtroom.
This specific detail is perhaps the greatest trap built into the new legislation. Many immigrants, particularly those unfamiliar with the labyrinthine nuances of U.S. immigration enforcement, do not realize the legal weight of their words.
Their own words.
Yes. The law is incredibly strict, applying the same consequence not just to a criminal conviction secured after trial, but to an admission of guilt regarding the offense.
Can you give us a specific hypothetical example of what the sources consider an admission that could trigger inadmissibility, even without a formal conviction?
The legal sources are very clear on this danger. Okay, scenario one, a non-citizen is pulled over, passes the field sobriety tests, but blows a borderline blood alcohol content, a borderline BAC.
So maybe not enough to prosecute.
Right. The officer asks, "Did you drink tonight?" The non-citizen, wishing to be cooperative and honest, says, "Yes, I had 2 glasses of wine an hour ago." If the state prosecutor later decides not to press charges because of insufficient evidence, that verbal admission, simply telling a police officer that alcohol was consumed before driving, can still be used as grounds for inadmissibility during a subsequent immigration proceeding.
Wait, so the case can be dropped, the individual is innocent under state criminal law, yet their status is still jeopardized?
Yes, because the immigration consequence is triggered by the admission of the essential elements of the offense, not the criminal conviction itself.
Unbelievable. What's another example?
Imagine a green card holder is questioned by an immigration agent during an application process, maybe for naturalization or a reentry permit. They're asked if they've ever been arrested.
Standard question.
They disclose a DUI arrest from 5 years ago that resulted in a plea bargain to a lesser, non-deportable offense. During the interview, the agent asked them to recount the incident. If the non-citizen described acknowledging that they were impaired when they were driving, that is, admitting the elements of the DUI offense, that admission, made years later, can be retroactively used as a basis for inadmissibility and removal proceedings under the new federal rule.
Wow! That fundamentally changes the required conduct for non-citizens in any interaction with law enforcement or government agents.
He does.
The legal protection they assume they had by, for example, cooperating fully, being honest, or accepting a plea to a lesser charge, has been completely stripped away by this emphasis on the admission itself.
It creates a legal minefield. Thousands of long-term residents who may have received a deferred prosecution, had their case dismissed on a technicality, or accepted a non-deportable plea to a lesser charge.
Thought they were safe.
Right. And who made an admission to an officer or judge years ago could suddenly find themselves facing removal. They never realized an admission, often made simply to cooperate or achieve a speedy resolution, held the same devastating weight as a formal conviction in this new framework.
That is an immense reach. Now, Congress, of course, had a strong rationale for imposing such a harsh position, especially one that disregards state-level mitigating factors. What was their stated goal here, beyond just general public safety?
Lawmakers explicitly argued that the goal was clear: to create a universal deterrent and to protect American citizens and residents by prioritizing absolute public safety standards among non-citizens.
So zero tolerance.
They claim that driving under the influence endangers lives, and by making a DUI an automatic and mandatory disqualifier, Congress believes it will enforce the strictest accountability possible.
This zero tolerance policy, then, is being used as the ultimate deterrent. It suggests that even a minimal risk to public safety is now an acceptable justification for revoking permanent status.
Indeed. And it's critical that the immigrant community understands that this is the new policy directive, and you can see that in the rare bipartisan support it received.
Right.
The legislative focus is no longer on the long-term ties or contributions of the individual when evaluating this specific behavior, but strictly on compliance with a zero-tolerance policy for this defined public safety offense. The severity just reflects the political will to enforce compliance at all costs for non-citizens.
We spent a lot of time dissecting the severe enforcement side of this reform, but as our sources carefully point out, this legislation is a duality. Congress created a real opportunity at the same time, providing significant new pathways forward.
That unique duality is why this law is so complex. For millions who have been in administrative limbo for years, this part of the law represents genuine hope.
Real progress.
It's potentially resolving decades of bureaucratic backlog and providing long overdue progress.
So tell us more about these new pathways. Who benefits, and what specific relief mechanisms have been created?
The reform creates several key mechanisms. The most significant is the modernization and expansion of existing registry provisions, which historically allowed some long-term residents to adjust their status. It also creates new, targeted visa categories, specifically aimed at reducing those massive family-based and employment-based backlogs.
How does this specifically address the backlog? I mean, we all hear about families waiting 15, 20 years for a visa to become current.
The new law incorporates recapture provisions, which means it allows unused visa slots from previous years to be reallocated. That's a huge deal.
So it's adding supply.
It's adding supply to the system. Furthermore, it updates the processing guidelines for certain individuals, like essential workers and immediate family members of U.S. citizens who may have entered without inspection, creating a formal in-country route for status adjustment.
So they don't have to leave the country.
Exactly. This offers a clear path for countless families to step into the light and pursue legal residency without the catastrophic requirement of leaving the country and risking inadmissibility.
So for families who have lived in the shadows, contributed to the economy, but had no formal path to status, there is finally movement toward a resolution.
There is, and the scale is enormous. This is the positive political compromise that allowed the tough enforcement measures to pass. It creates a formal route for millions who meet specific criteria related to how long they've been here, their employment history, and family ties. As we transition, this opportunity comes with a single, very serious, and newly stringent condition.
And that condition is the crucial hurdle of demonstrating good moral character, or GMC.
Correct. To qualify for any of these new benefits, applicants must demonstrate good moral character. And while GMC has always existed as a prerequisite for naturalization and other forms of relief, under this new reform, its definition has been tightened and codified in a way that aligns perfectly with the new, strict enforcement mandate.
This tightening is the crucial intersection point. If you want the benefit of legalization, you must pass the GMC test, and the rules for passing are now profoundly stricter.
That's right. The legislation details specific evidentiary standards required to demonstrate GMC. This goes way beyond just a basic background check.
What does it entail?
It requires comprehensive documentation, including detailed financial histories, tax compliance for the entire period of residence, proof of compliance with selective service requirements, if that's applicable, and clear evidence of consistent support for family obligations, like child support.
That seems like an enormous administrative burden, especially for people who might have been undocumented and thus lacked formal records for years.
It is a massive burden, which is why the application process requires meticulous preparation. But the biggest barrier is the criminal history component, and this is where that DUI provision casts its enormous shadow.
Let's connect the dots again. How does the Section 2 severity impact the Section 3 opportunity?
A DUI, whether it resulted in a conviction or critically a proven admission, now automatically disqualifies someone from being considered a person of good moral character, making them ineligible for these new pathways.
So that seems like an absolute barrier. If a person had a DUI 15 years ago, before this reform, and they're now applying for one of these new legalization pathways, are they just completely out of luck? Is there a look-back period?
The law is structured so that if the underlying act, the DUI, or the admission of the essential elements of the crime occurred within the statutory look-back period for GMC, you are barred.
And what is that look-back period?
It's typically 5 years for naturalization, but it often extends indefinitely for specific disqualifying criminal acts like this new DUI classification. Because the DUI is now classified as a mandatory ground of inadmissibility, it's viewed as a fundamental bar to GMC, regardless of how minor the state courts treated it.
So lacking GMC now becomes a total barrier to opportunity. What are the specific consequences of being deemed lacking in good moral character under this new framework?
The consequences are immediate and devastating. First, you cannot apply for citizenship. Second, you cannot renew certain existing immigration benefits that require a finding of GMC upon renewal. And third, and most importantly for this conversation, you are automatically barred from accessing the new programs and legalization pathways created by this very reform.
This means even if the government creates a new pathway specifically designed for, say, essential agricultural workers who have been here for 15 years,
Right.
a single DUI from the past, or even a past admission of guilt about drinking before driving, can instantly negate that opportunity.
It acts as a complete and immediate block. And this barrier is not easily removed. It stays on the individual's record and can only be overcome if the government grants a very specific limited waiver, which, as we discussed, is now much harder to obtain due to the removal of judicial discretion.
This really demonstrates the unique combination the sources highlight. The government is opening new doors.
But the required standard of conduct to walk through them is now exceptionally high and unforgiving.
The message is, we are willing to offer long overdue progress in legalization, but only for those who can demonstrate a near flawless record of moral fitness as defined by these new, strict standards.
Precisely.
Did the sources suggest any specific challenges the government faces in implementing this dual system? I mean, this has to be a bureaucratic nightmare.
Absolutely. The administrative challenge is immense. U.S. Citizenship and Immigration Services, USCIS, must now process millions of complex applications for these new pathways while simultaneously enforcing the stringent new rules.
So they're getting squeezed from both ends.
Exactly. This requires an enormous increase in staffing, training, and database harmonization, especially since state-level records about convictions and admissions are notoriously difficult to standardize and share federally. There's a real concern among policy analysts that the system could just buckle under the weight of this dual mandate.
So the opportunity is real, but the required level of perfection combined with the administrative difficulty means that many who should be eligible may still struggle to achieve status unless they prepare flawlessly.
Precisely. The standards have been set extremely high. The community needs to understand that simply being eligible under the broad category of the new law is not enough. The individual character and evidentiary requirements have been fundamentally altered. Meticulous documentation, clean legal records, and absolute honesty in applications are completely non-negotiable.
It makes the preparation process for these new pathways critical. It's so much more than just filling out forms. It demands a comprehensive legal review of one's entire life history in the United States.
Indeed. The pursuit of legalization now requires a level of caution and preemptive legal review that was never necessary before. The potential benefit is freedom from the shadows, but the cost of noncompliance is potentially deportation.
This reform serves as a stark and really an unavoidable reminder about the absolute limits of a green card, particularly for those long-term residents we discussed in Section 1. The window of security that permanent residents once enjoyed has narrowed significantly because of the reclassification and these enforcement mechanisms.
That is the ultimate takeaway for anyone currently holding a green card or permanent resident status. Green cards provide security, yes, but only up to a point, and that point has just been pulled back dramatically.
And citizenship.
Citizenship is the only true protection against the federal government's ability to revoke your status.
Let's define that shield clearly. In technical legal terms, what does U.S. citizenship offer that the permanent green card cannot, especially in the context of these new laws?
The difference is constitutional permanence. As a U.S. citizen, your status is generally inviolable. You cannot be deported, nor can you lose your right to live here because of a DUI or any other offense that falls short of the most serious crimes like treason or certain kinds of fraud against the state.
So the consequences just become legal or judicial matters.
Right, handled by the criminal justice system, but they are no longer immigration matters handled by Homeland Security.
So the criminal process and the immigration process are fundamentally delinked for a citizen, whereas for a non-citizen, even a green card holder, they are now more dangerously intertwined than ever before.
Exactly. The rights of citizens are protected by the Constitution itself, specifically the 14th Amendment. That makes the ability to live, work, and remain in the United States permanent and unconditional, barring extraordinary circumstances.
And a green card.
A green card, by contrast, is a privilege granted by the government, which, as we've just seen, can be revoked or severely curtailed by new legislation passed with bipartisan support.
That distinction, privilege versus constitutional right, is the core message of this entire reform. For many people who've been delaying the naturalization process, maybe seeing it as just an option or an expensive formality, the calculus has changed completely.
It has shifted fundamentally from an option to an absolute necessity. This reform should serve as the most urgent wake-up call for anyone who has been putting off that decision.
It's an alarm bell.
It is. The vulnerability that non-citizens now face under these new rules, especially regarding something as common as a DUI admission or conviction, makes the need for the shield of citizenship urgent and immediate.
Let's discuss the practical challenges of naturalization in this new atmosphere. If someone is a long-term green card holder, they're likely eligible now, but the process is arduous.
It is. The process requires time, usually several months to a year or more, careful documentation proving 5 years of continuous residence.
Or 3 years if you're married to a U.S. citizen.
Right. And an understanding of U.S. civics and history and proficiency in English. Given the urgency, administrative backlogs are likely to increase, making delays almost inevitable.
And what about the cost? Naturalization is expensive, which is often cited as a major barrier for eligible residents.
That financial barrier remains significant. The application fees are substantial, and when you factor in the cost of legal assistance, which is now more critical than ever given the increased scrutiny on background in GMC, the total expense can be prohibitive for working families. But that cost must be weighed against the potentially infinite cost of deportation and the destruction of life built here. The protection it offers is worth every bit of effort. If you are eligible, the time to act is now, before further regulatory changes or complications arise.
This emphasizes the vigilance message we have to impart to our listeners. The stakes have changed, and the consequences are now more severe than they have ever been, not only for potential new applicants, but for established residents.
Absolutely. For non-citizens, the mandate is clear. You must stay hyper-vigilant, follow every single rule, and avoid any risky situations that could trigger the DUI provision.
What does that mean in practical terms?
This includes avoiding driving if you have consumed any alcohol, regardless of how minor the amount, due to the risk of an admission of guilt during a traffic stop. The old, more lenient standards simply do not apply anymore.
That level of required caution is intense. Even minor mistakes under this new system can matter more than ever imagined.
That's the reality. And the path forward, whether you're pursuing citizenship or seeking the new benefits created by this law, is narrow and unforgiving. It requires clean records, honest applications, and explicit proof of good moral character, as defined by the new high standard.
Any misstep,
be it an error on a form, an accidental omission, or a minor legal issue that now falls under this broadened enforcement net, can result in denial, deportation, or permanent ineligibility.
This is not the time for shortcuts, for relying on outdated advice, or for assuming minor infractions will just go unnoticed.
Not at all.
The complexity of immigration law, already challenging, has just been compounded by this comprehensive and somewhat contradictory reform.
That is the mandatory advice. If you are a non-citizen and you have any doubt about your status, your eligibility for the new programs, or the potential impact of any past mistake, even a minor traffic incident where alcohol was mentioned, you must consult with a qualified, experienced immigration attorney.
You just have to.
You have to. The margin for error is smaller than it has ever been. And a single mistake in how you handle an interaction with authorities could determine whether you stay in America or lose everything you've worked for.
The immigrant community in the United States has truly entered a new era of required caution and heightened awareness. This new law creates immense pressure to seek out the ultimate security of citizenship. So, to summarize the unique balance of this historic law, it's a profound duality.
Hmm.
It is undeniably a severe warning, tightening the rules, strengthening enforcement, and vastly reducing the margin for error for non-citizens, including long-term green card holders through measures like the DUI provision.
But it is also a significant opportunity. It opens new legislative doors and provides new hope for legalization for millions who meet the incredibly high standards of eligibility and demonstrate the required good moral character. It offers a formal path out of the decades-long backlog.
The standards have been set, and millions must now adjust their lives accordingly. The political cooperation that achieved this, that rare bipartisan agreement, signals a clear, unified government message.
And that message is,
If you want full, unconditional protection and permanence in the United States, you must pursue citizenship. And until then, you must follow the rules without exception.
what's most striking and what I think will have the deepest societal consequence is the law's expansive definition of a trigger event.
The admission of guilt part.
Exactly. By including not just formal convictions, but also an admission of guilt as grounds for inadmissibility and potential deportation, the reform doesn't just change legal standing. It fundamentally requires non-citizens to drastically reassess and limit their social and legal interactions to an unprecedented degree.
That required level of hypervigilance, that fear of answering honestly during a routine traffic stop, must be exhausting.
It is a profound shift that goes far beyond the letter of the law, and it raises an important question for you, the listener. Given that a single admission of drinking before driving can now lead to the permanent destruction of a life built over decades, what societal effects will this new required level of constant caution have on immigrant communities? Will it lead to increased social isolation, reduced cooperation with local law enforcement, and a deep systemic distrust of legal processes? That is a profound question millions are now forced to live with every day.